Now, you'll recall that the Supreme Court has just sunk Section 5 of the Voting Rights Act. And Section 3, which is the basically the pre-clearance. There was about a dozen states or specific counties, in counties within that states, that required pre-clearance from the Department of Justice because of their history, because of a formula essentially that was devised. I should say in Section 4 was struck down. A formula that was devised in Section 4 for states that had had a history of racial discrimination in their voting, and therefore were subject to Section 5, wherein these states needed to seek permission, essentially from the Department of Justice, pre-clearance, to change their voting rules. There's another provision of the Voting Rights Act, Section 3, which is a bail-in provision, wherein the Justice Department can find that states, any given state or county, has engaged in similar practices more recently, which suggests that they would be now subject to pre-clearance. The Supreme Court invalidated the formula for the existing pre-clearance. It did not invalidate Section 3, which said the Department of Justice can go to court and say, because this state or county or municipality has been engaging in nefarious practices in curbing the voting rights of its citizenry, they are now subject to pre-clearance. That is what the Department of Justice has announced it's going to be doing now in the case of Texas. When a state has a history of discrimination in voting, as Texas has been found to do most recently, remember, a court struck down their redistricting plan in the case Texas v. Holder. And therefore, that is prima facie evidence that they are attempting to restrict voting rights in a fashion that would subject them, again, to Section 5. And so the Supreme Court has announced, the Department of Justice has announced, based on the evidence of intentional racial discrimination that was presented last year in the redistricting case Texas v. Holder, as well as the history of pervasive voting-related discrimination against racial minorities that the Supreme Court itself has recognized, we believe the state of Texas should be required to go through a pre-clearance process whenever it changes its voting laws and practices. That is an announcement by Attorney General Holder. There's also a suggestion that there will be a lawsuit against Texas voter ID law because similar laws have been struck down in federal courts. And so this is basically a way for the Department of Justice, short of Congress dealing with creating a new formula to subject people to Section 5 via Section 4, this is a way for the Department of Justice to bail in now people into the, or I should say states or municipalities, entities, into the pre-clearance requirement. So this is going to be very interesting to see how this plays out, because this is a very bold, but it's an aggressive move by the Department of Justice. One that's certainly appropriate, but it's good to see them play this out.